Convention on Rights of the Child, CRC, breaches. International protective measures to prevent abduction of Cassandra Bersad precede, and take precedence over Switzerland's domestic measures. Swiss authorities have limited and prevented father-slash-daughter relations, and inflicted permanent damages by incorporating discriminatory opinions of the other parents' campaign to estrange Cassandra from her father and American family, all based on accusations every year since 2018 that I will kidnap my own daughter, despite I notified the FOJ and all parties since February 2018, by international protocols of the Hague Abduction Convention's access application and KP's enrollment in the Children's Passport Issuance Alert Program, CPIAP, an international measure taken by a parent for the prevention of international child abduction, as described in the document. CX-24, CPIAP confirmation email of February 2, 2018, U.S. Central Authority. CX-25, CPIAP confirmation of July 28, 2023. The annual routine of LJ accusing me of attempted kidnapping, the Justice of Peace ruling on her opinions to restrict KP from access and personal relations with her father while denying my right to be heard, then passing off the duties of supervised visitation to incompetent so-called facilitators who lie on record to cover of their incompetence, lack of communication, lack of availability within a reasonable time frame, and lack of cooperation with this international father has continued each and every year since 2018, but when jurisdiction was transferred to VOD in July 2020 to Judge Eddie Vincani, this case turned into a comical case, rather than a civil case for any spectator who was not the actual victim of the Swiss gang's rights violations. After submitting my Hague access applications of 2020, Judge Eddie Vincani ruled in favor of the child hostage mother to stop all video contacts between my daughter and I because LJ brought to his attention my home videos of my daughter and I that I have been uploading to YouTube for the previous 4 years, normal activity in the USA. While using the excuse of home videos to cut father-slash-daughter relations, the actors at the DGEJ and Judge Vincani covered up the reported criminal convictions of LJ's federal narcotics violations for drug possession in a public park, international drug trafficking, shoplifting thefts, and non-compliance of judicial orders for withholding KP from access rights of August 2018 in maintaining favoritism of a Swiss criminal custodial parent of a minor, as previously detailed to the OHCHRN. Violations to Article 33 of the CRC. While the FOJ, Judge Vincani, and DGEJ nonchalantly dismissed drug dealing in a park and international drug trafficking of LJ as 1 or 2 incidents, have covered up the evidence of the following 4 pictures which clearly show paraphernalia, KP in the presence of paraphernalia, LJ smoking drug in front KP, and screenshot picture of November 16, 2017 when LJ wrote, "I've sold a lot of marijuana to survive, don't forget that either." Herein is Exhibit 26. In 2021 the accusation by LJ was that I will kidnap Cassandra by paddle boat. Somehow, Judge Eddie Vincani was convinced that I would paddle a boat, like you would pedal a bicycle, across the Atlantic Ocean from Lake Geneva, and decided to restrict visitation on these ridiculous accusations in 2021. In 2022 the accusation by LJ was that I will kidnap Cassandra by helicopter. Judge Eddie Vincani violated the access rights of my daughter and I, and was convinced that I have resources like James Bond or would get the pilot of a public helicopter tour company to take a crowded helicopter with other tourists and transport my daughter and I to the USA from Switzerland. Whether the helicopter would need refueling or runs on solar power was possibly considered in the comical court's decision to cut off visitation rights for 6 months. Exhibit 27, July 1, 2022, I appealed, LR 21.002682/EVL/MBN, K21-267-1HUF, the nonsense decision and all the falsified facts to the Tribunal of VOD, only for their decision to overlook all merits of law and actual endangerment of KP, but they decided to dismiss the appeal based on money that they wanted for international access proceedings to cover for the first instance. Judge Rouleau of the tribunal covered up Judge Vincani's child rights violations by rendering my appeal as inadmissible for court costs is unlawful, as I am an international applicant for Hague Convention of October 25, 1980 on the civil aspects of international child abduction. Switzerland being a contracting state of the Hague Abduction Convention, which clearly states that the state of jurisdiction bears the costs in access proceedings, not the applicant of a different contracting state, as all the articles violated are detailed in Exhibit 27. The tribunal's unlawful inadmissibility reasoning to dodge the facts and evidence that I presented in my appeal of July 1, 2022, was then followed by X28, and supporting evidence within X1 and X2, my appeal of November 29, 2022 Swiss Supreme Court. February 28, 2023, Judge Herman of the Swiss Federal Supreme Court covered up Judge Rouleau's child rights violations, which covered up Judge Vincani's child rights violations, with blatant lies to support his reasons to dismiss my appeal based on admissibility criteria, by falsifying facts in paragraph 4, to erroneous conclusion of paragraph 6, mentioned that my appeal was not registered within the deadline of 30 days, and that it was in English. Judge Herman wrote, 4. Contrary to what the appellant seems to maintain, the appeal letter dated November 29, 2022 reached the court for the first time attached to his email of February 22, 2023. However, an appeal transmitted electronically must bear the qualified electronic signature of the party. Rather than holding the FOJ accountable for not doing their job of transmitting the appeal since November 29, 2022, as they stated in X29, the only deadline under the Hague Access Right procedure is the one pertaining to the Swiss Federal Supreme Court, appeal of the decision from November 7, 2022, after receiving my appeal within 10 days prior to the deadline. As proven transmitted by U.S. Central Authority in Exhibit 29, the judge made excuses for the FOJ's incompetence to, once again, strategically and illegally violate my right to be heard. Exhibit 28. My appeal is clearly in English and French languages, though the Supreme Court breached international law and my right to be heard, once again, by providing its decision in French to English-speaking USA, and by direct postal mail for non-compliance of international protocols. X28 supporting evidence is clear communication between central authorities, as I was in compliance of Hague Abduction Convention of October 1980 access protocols in transmitting all my documents by central authority for the entire case and all three instances/courts. On November 9, 2022, the U.S. Central Authorities Mr. Darnell Posey confirmed proof of service in providing me with a copy of Judge Rouleau's decision, a brief explanation, and indicated that 30-day deadline to appeal to the Supreme Court was in effect as of November 9, 2022. Referring to the Vaud Tribunal's court fees for international access proceedings, Mr. Posey wrote, according to the information in the decision, the father failed to pay the advance payment to the court, which would normally lead to immediate refusal of the filing, inadmissibility. Referring to the deadline to respond, he wrote, this decision can be appealed at the Swiss Federal Supreme Court within 30 days of service of documents. On November 29, 2022 at 5:05 a.m., by legal channel in the USA, I emailed the U.S. Central Authority my Supreme Court appeal within 20 days of the 30-day deadline, and provided all parties with a copy by carbon copy, CC, to the same email. On November 29, 2022 at 9:05 a.m. Eastern Standard Time, Mr. Posey confirmed in his email that my appeal was sent to the Swiss Central Authority, FOJ, and that the FOJ clarified their job of being responsible only for Hague access right proceedings and reminded me that I have 30 days to provide the Central Authorities with my Supreme Court appeal. He wrote, Dear Mr. Prasad, your recently provided documents will be forwarded to the attention of the Swiss Central Authority, SCA. For your reference, the SCA has stated that the only deadline under the Hague access right procedure is the one pertaining to the Swiss Federal Supreme Court, appeal of the decision from November 7, 2022. The deadline is 30 days from the moment of service of documents. CX29, emails of November 29, 2022, once again proving Switzerland's violations of international protocols, my civil rights, and CRC rights of my daughter. Switzerland clearly breaches the Hague Abduction Convention Article 22, no security, bond or deposit, however described, shall be required to guarantee the payment of costs and expenses in the judicial or administrative proceedings falling within the scope of this convention. Article 26. Each central authority shall bear its own costs in applying this convention. Central authorities and other public services of contracting states shall not impose any charges in relation to applications submitted under this convention. In particular, they may not require any payment from the applicant towards the costs and expenses of the proceedings. Article 30. Any application submitted to the central authorities or directly to the judicial or administrative authorities of a contracting state in accordance with the terms of this convention, together with documents and any other information appended thereto or provided by a central authority, shall be admissible in the courts or administrative authorities of the contracting states. I can clearly see how Swiss secrecy and privacy laws are used as veils to hide decades of routine fabrications of fairy tales and lies masking incompetence, and deliberate civil rights violations of parents and children is also being applied to the Prasad family, but unfortunately these U.S. citizens are protected by U.S. laws, multilateral, and unilateral conventions. Ongoing permanent damage and civil rights violations routinely began for 2023 in June, when the Swiss fabricated an unlawful arrest warrant to aid LJ in preventing access to my daughter, and in July when Judge Eddie Vincani took the opinions of LJ to violate the rights of my daughter in ida personal relations by restricting contact to confined visitation supervised by third parties that then refused to facilitate supervised visitation for any part of 2023. U.S. law makes public all records and full disclosure of all the case files and documents, while my international press credentials are providing free advertising for the unveiling of career criminals with law degrees or with 2 husbands and criminal records of abusing my daughter. It now makes sense why the FOJ has lied about not being mandated to the articles of the Hague International Maintenance Convention, because they can't collect child support from someone they didn't legally divorce and still shares equal custodial and parental rights to KP, due to them never respecting international protocols whatsoever of the Hague Divorce Convention, 34 Convention on Jurisdiction, International Mutual Legal Assistance in Civil Matters Treaty, Hague Service Convention, and later on including the Mutual Assistance in Criminal Matters Treaty. Further rendering invalid all divorce judgments are blatant violations of 28 Convention of October 25, 1980 on the civil aspect of international child abduction, which support my claims of a multitude of CRC violations and my daughter being a Swiss hostage. Conclusion. In conclusion, an exhaustion of domestic remedies for this ethnic Indian and American citizen does not exist in Switzerland among corroborating criminals breaking the law within every level of the administration, judicial and executive branches. I will not go over boring facts and evidence in this conclusion that anyone with common sense can determine the connection between all of my claims and irrefutable evidence herein, but I will close with 2 final pieces of new evidence. On July 26, 2021, notice of registration of the Swiss divorce within the contracting state, the USA. On July 30, 2021, Layla Jaksic contested the registration of the divorce in what I believe to be a spiteful attempt to prevent me from remarrying, as she maintained the legal validity of the marriage of September 2, 2014, despite she began committing adultery in 2017, and began engaging in polygamy in 2020, as she therefore maintained my equal custodial right and parental authority of Cassandra Prasad. The entire Swiss civil case pertaining to matrimony, access, and divorce is invalid, null, void, and has no authority over Devendra and Cassandra Prasad as both of her parents maintain the validity of the marriage that KP was conceived in. Domestic laws were breached in unlawful initiation of proceedings, international laws were breached in failure to dissolve the marriage, and civil rights of my daughter and I continue to be breached by Swiss authorities on said territory. CX30, July 26, 2021 Notice of Divorce Registration, and X31 Washington State Certificate of Marriage, of September 2, 2014, certified by the Director of Records and Licensing of King County on September 22, 2023. My response to the Office of High Commissioner of Human Rights of March 6, 2023 is maintained. My filings to the OHCHR of October 2020, May 23, 2022, and August 7, 2023 are maintained. Switzerland's violations of Convention on the Rights of the Child, Articles 2, 3, 4, 5, 7, 8, 9, 10, 11, 12, 14, 16, 18, 19, 24, 25, 26:2, 27:4, 28:3, 29:1, C, 30, 32:1, 33, 34, 35, 36, 37, A, 39, 41, B, 44:2 is maintained. Regards. On behalf of Cassandra Amina Prasad. Devendra Prasad, October 9, 2023.
Exposing dirt bags. Here we go. Here's a little visual. A little visual of my baby. This is the missing poster that's gonna go up. Because I'm sick and tired of dealing with scumbags.